Good afternoon, everyone. This is Dr. Claire Broughton, and today we'll be discussing Chapter 7 on kidnapping and related offenses. So, to give you a brief history of the federal law on kidnapping, we have to discuss the Lindbergh Act. This is a statute authorizing the Federal Bureau of Investigation to investigate ransom kidnappings. I have here a video of the details and the outcome of the prosecution of the offender in the Charles Lindbergh kidnapping. So I want you to view this video at your own time. I also uploaded it on Blackboard so you can see it and also view it at your own time. Kidnapping historically has also been used as a political tool. And we have throughout history and in current times, the abduction of journalists, relief workers, soldiers, and other foreign citizens during recent conflicts in the Middle East. And, historically, we have here the kidnapping and abduction of newspaper heiress Patricia Hearst in San Francisco. Now, under common law, kidnapping was the forcible abduction of a person and sending him to another country. This was the term asportation. So there were political abductions, forcing persons into involuntary servitude and conscription of soldiers. Under common law, you also have the crime of false imprisonment, which would make the offender civilly liable for damages. The U.S. statutory law expanded coverage to ransom kidnappings in view of Charles Ross kidnapping in 1874 and later the enactment of the Federal Lindbergh Act in 1932. There were also child abductions by sexual predators, and in response to this, the U.S. has implemented several programs and policies to enable the public to help apprehend sexual predators who had abducted children. An example would be Code Adam. So in department stores, when a child is reported separated from his or her parents in the store, an announcement is made of the child's description. Employees and shoppers are urged to be vigilant in locating the child. If the child is not found in 10 minutes, the law enforcement authorities are notified. Another example of a program in the United States is the Amber Alert, and this is basically a descriptive information of the child and abductor, including the vehicle, which are broadcasted over participating radio and television stations. In addition, electric signage is shown on certain areas on the freeways. Under Texas law, there are several types of kidnapping. First, at the lowest level is unlawful restraint, and then you have kidnapping, and then aggravated kidnapping. So that's aggravated kidnapping and other abduction-related offenses. First, what is unlawful restraint? This is the offense where a person intentionally or knowingly restrains another person. So what does it mean to restrain another person? You restrict a person's movement without consent to interfere substantially with their liberty by moving them from one place to another or by confining the person. Okay? How do we know if the restraint is without consent? First, if it's accomplished by force, intimidation, or deception. Second, the victim is under 14 and the parent has not consented. Or third, the victim is 14 to 17 and the victim is taken out of state and 120 miles from home without parental consent. Unlawful restraint is a Class A misdemeanor to a felony of the third degree. Let's look at this particular case of unlawful restraint. Unlawful restraint requires an intentional or knowing mens rea. You cannot commit unlawful restraint through the mens rea of negligence, or recklessness. Let's look at this case. Paul locks up his restaurant, forgetting that Roderick is still in the kitchen washing dishes. Did Paul commit unlawful restraint? No, because here he forgot that Roderick is still in the kitchen. Okay, so this is at most a case of negligence. The second case, Dan, the high school math teacher, purposefully locks Pam into the classroom closet. He leaves her there for an hour to teach her a lesson. Did Pam commit unlawful restraint? What do you think, class? Here, yes, because the intent was to lock Pam in the classroom closet, and how do you know it's intentional? He did that so that Pam would teach her, so that Pam would learn her lesson. Now, let's look at the concept of restriction. How do we know that you restricted the victim's movement? Restriction requires confinement or substantial interference with liberty. There is no time limit on the period of confinement. So if you confine the victim for a few seconds, a few minutes, there would still be restriction. And this was elaborated on in the case of Rodriguez versus State. Here, Rodriguez climbed into the high school student's car and threatened her with a knife. The student struggled with Rodriguez for about 2 minutes until a crowd gathered and Rodriguez abandoned his intentions. The court held that here there was substantial interference of liberty. Note that in this case, the restraint was only about 2 minutes, okay? But it was still considered a restriction on the victim's movement because within that time of 2 minutes, the high school student was unable to freely move about. What is kidnapping? Section 20.03 of the Texas Penal Code defines kidnapping. There are several elements of kidnapping. First, the person has to have an intentional or knowing mens rea. Second, the person abducts another person. How? Well, there are two forms of abduction. First, restraining another with intent to prevent liberation by secreting the victim, meaning that you hold the victim in a place where they are not likely to be found, okay, so concealing them. And second, using or threatening to use deadly force. What is deadly force? Anything that can cause serious bodily injury or death. However, it's not an offense for a relative to abduct another to regain lawful control of the victim, as long as no deadly force is used. Kidnapping is a felony of the third degree. Let's look at this case scenario. Katie leaves a message on Tom's answering machine that she no longer wishes to be his wife. Tom becomes enraged that Katie would end their relationship, and he forces her into his car, drives around the neighborhood, waves a firearm at her, and threatens to kill her or Suri if she does not change her mind. Is there abduction of the victim? Yes, there is, okay? Because first, the threat to kill her, this is actually deadly force, and this would be kidnapping. In fact, it would be aggravated kidnapping, okay? Because of the use of a deadly firearm, exhibiting a deadly firearm. Now, let's look at this other case. Dan decides to kidnap Pam, a 14-year-old child, and makes a ransom demand from Pam's parents. Dan is successful in taking Pam against her will. He ties Pam with ropes and hides her in the bedroom of an abandoned house. When Dan leaves to telephone Pam's parents, Pam slips from the rope and escapes. Was a crime of kidnapping committed by Dan? Yes. Okay. The fact that the victim, Pam, was able to escape does not change the fact that this is a completed kidnapping on his part. So the fact that Dan intended to ask a ransom from Pam's parents and tied her against her will completes the act of kidnapping. It is aggravated kidnapping when the following circumstances exist. So first, if you commit kidnapping and you have the intent to either do any of these 6 circumstances, it elevates the crime from simple kidnapping to aggravated kidnapping. First, if you ask for a ransom or reward, when you hold the victim. Second, if you use the victim as a hostage, for example, to prevent, to enable you to escape from the scene of the crime. Third, if you use the victim to facilitate another felony. Fourth, inflict bodily injury or sexual abuse on the victim. Six, terrorize the victim or a third party. And then finally, to interfere with the government or political function. The other form of kidnapping, okay, aside from the first category, the second category is when you commit kidnapping and you use or exhibit a deadly weapon. So that would be aggravated kidnapping. This is a felony of the first degree, but it becomes a felony of the second degree if you release the victim to a safe place. Let's look at this case scenario. What do we mean by facilitating another felony, right? Okay, this is in the third classification of the first category. So commits kidnapping with intent to use victim to facilitate another felony. Let's look at this case. Dan robs a bank and then carjacks Pam and forces her at gunpoint to assist his getaway. This would be using the victim as a hostage under number 2. Okay. And then the second case, Felix and Oscar decide to rob a jewelry store in Fort Worth. Wearing masks and armed with pistols, they enter the store. Felix forces all store employees and customers into the employee break room, while Oscar takes jewelry from display cases. Just as the two are about to flee the store, police arrive. In panic, Felix grabs the store manager. Using her as hostage, he and Oscar exit the store. Now, in addition to the aggravated robbery charge, will Felix and Oscar be facing the aggravated kidnapping charges? What do you think? Well, the Texas law follows the minority view. The minority view would state simply that the offenders would be liable for aggravated kidnapping for forcing the persons into the break room and for the act of taking the manager as hostage. Now, going back, what is the majority view? The majority view followed by other states is that kidnapping statutes do not apply to unlawful confinements or movements incidental to the commission of other felonies. So looking back at this example, there are two forms of restraint here. First, forcing all the store employees and customers into the employee break room. This, according to the majority view, this is simply incidental to the commission of the crime of aggravated robbery. So Felix and Oscar would not be facing additional aggravated kidnapping charges for forcing all of these employees and customers into the employee break room. However, they would be liable for grabbing the store manager and using the store manager as hostage. As I mentioned, Texas follows the minority view, and they would be liable for aggravated kidnapping for both acts of forcing the persons into the break room and taking the manager as hostage. So going back again in this case, under Texas law, the offenders, Felix and Oscar, would be liable for aggravated kidnapping charges in addition to the aggravated robbery charge. Okay? As I mentioned, aggravated kidnapping is a felony in the first degree. It becomes, or it's lessened to a felony in the second degree, a lower rank, lower in terms of seriousness, if they release the victim into a safe place. So how do we know if it's a safe place? Factors to consider. First, remoteness of location. How remote is it from civilization? Second, proximity of the authorities or person who could aid or assist. For example, law enforcement officers or any passerby. If there are vehicles that go through that place, okay, then it becomes a safe place. Time of day. If you release the victim during the day, it's more safe as opposed to the night. Climatic conditions. If you release a person in temperate weather, it's considered a safe place. But if you release the person in the middle of a desert where it's really, really, really hot, or in cold, freezing winter climates, it would not still be a safe place. Also, you look at the victim's condition. Was the victim healthy, in normal condition, or was the victim in a weakened condition because you tortured the victim or you injured the victim severely? And finally, the character of and the victim's familiarity with the location or the neighborhood. Now, there are several other abduction-related offenses. First, interference with child custody. Second, unlawful transport. And third, trafficking of persons. Now, look at this parental abduction case. Roger and Dolores are in the process of getting a divorce. Their son Eddie is 8 years old and in third grade. One day, instead of taking the school bus home, Eddie is met in school by his father, Roger. Eddie and Roger depart in Roger's automobile. When Eddie does not come home in the bus, Dolores becomes worried and calls the police. Has Roger committed a crime? Yes, this would be parental abduction. In fact, approximately 200,000 children are abducted annually by the non-custodial family member. For example, the father. We have several laws that govern parental abduction. First, you have the Parental Kidnapping Prevention Act of 1980, which governs responsibilities of states in enforcing out-of-state custody orders. In Texas, you have the Interference with Child Custody Law, which give police officers legal basis to intervene in parental abduction cases until custody rights are clearly established by civil court system. Let's look at interference with child custody under Section 25.03 of the Texas Penal Code. The elements are: person takes or retains a child under 18 in violation of the express terms of a court custody order. But for the person to be liable for interference with child custody, the person must know the existence and terms of the court order. Let's look at this case. Ken and Barbie are divorced. During divorce proceedings, Barbie was awarded custody of the twins, while Ken was granted visitation rights every other weekend. One weekend, Ken picks up the children, but without telling Barbie, takes the twins on a week vacation at the beach. Did Ken commit interference with child custody? Yes, because it's in violation of the custody court order. Second form of interference with child custody is when the person not granted custody takes the child under 18 out of the jurisdiction of the court without court permission. But the offender must know that court proceedings are pending. And the intent must be to deprive the court of authority over the child. Okay? It's an absolute defense that the offender return the child to the judicial district or county where the district or county court has jurisdiction within 3 days from the date of commission. So even if it takes even if the offender takes a child under 18 out of the jurisdiction of the court or of the court, if he returns the child within 3 days, then it's an absolute defense. The parent cannot be charged or liable for interference with child custody. Now let's look at unlawful transport. This is the commercial transportation of undocumented migrant workers. The intent is for pecuniary benefit, and the manner of transportation is to conceal the individual from law enforcement authorities and to place the immigrants at substantial risk of serious bodily injury or death. Human smuggling and trafficking of persons are governed by several laws. First, you have the Trafficking Victims Protection Act, which tries to protect people from being forced into commercial sex or forced labor. What is human smuggling? Human smuggling is illegal immigration in which an agent is paid to help a person cross a national border clandestinely. Chapter 20A considers this a felony, okay? And in contrast to human smuggling, what is human trafficking? Human trafficking is forcing the person into forced labor or forced prostitution. In the United States, 800 to 900, 17,000 to 500, 17,500 to 18,500 are trafficked into the United States. On the other hand, 800,000 to 900,000 victims are trafficked globally per year. It's the exploitation of unwilling or unwitting people through force, coercion, threat, or deception. Usually, the victims are women and children from the Middle East, Eastern Europe, Mexico, and Central America. Let's look at several of these cases of human smuggling. First, Tyrone Williams, a 36-year-old Jamaican citizen living in New York, locked more than 70 immigrants in a container truck during a 2003 trip from South Texas to Houston, but abandoned the truck about 100 miles from its destination. The victims died of dehydration, overheating, and suffocation in the Texas heat before the truck was discovered and its doors opened. Let's look at this other case, okay? This is human trafficking. In February 2007, 34-year-old Juan Balderas Orozco and 11 associates illegally brought hundreds of women into the U.S. from Latin American countries and forced them to have sex with as many as 40 men a day. The women were moved between more than a dozen brothels in Texas and Oklahoma to keep them disoriented and prevent them from making friends in the community who might help them. Juan et al. Were convicted in federal court in Austin, Texas for human smuggling. Thank you so much for watching this lecture, and I hope you learned something. You learned a lot from this, and I'll see you next for next recording, and have a good day.